Hello and welcome to this presentation from ENSICHTEN. My name is John Wallace and today we're going to talk about CCPA and what that means for your business. Privacy and data regulation within the United States is nothing new. However, many organisations are just starting to focus on it given the news of substantial GDPR fines. GDPR being Europe's privacy law. CCPA actually took a lot of influence from GDPR. And if you read the text, you can see similar business requirements within the legislation. While many people are at least aware of HIPAA and how that law governs your medical records, there are in fact many laws designed to protect consumers and their information, and the graphic here shows some of them. Over the years, we've seen acts such as the Children's Online Privacy Protection Act take aim at online activities focusing specifically on consumer data and how it's handled by businesses. But privacy laws are not just passed at the federal level. States themselves have also taken legislation or enacted legislation about what organisations can do with the data of their citizens and their residents. Illinois, for example, has the Biometric Information Privacy Act, which governs what businesses can do with information such as fingerprints and what can happen with that information once a user discloses it to the business. So, with that in mind, let's focus on California's laws, CCPA or the California Consumer Privacy Act. So, what is the CCPA? The CCPA is designed to protect California citizens in terms of how their personal data is collected and used by businesses. It establishes new rights for consumers relating to the access to their data, the sharing of their data, and the user's right to have their data deleted upon their request. CCPA was first enacted in 2018, meaning that it was signed into law by the California government. In terms of its application, the first part, which deals with breaches when data is stolen or leaked, went into effect at the start of 2020. The second part of the law, which deals with aspects such as consumers being able to opt out of the sale of their data, goes into effect this year in July. CCPA has a spectrum of tests to decide whether an organisation must comply with the law. The first being that the organisation must collect the personal information of California residents. This doesn't mean that the business needs to be located in California, but just that they have California-based customers and collect data on those customers. If they do this or they have those types of customers, then they're potentially bound by CCPA. In addition though, businesses must also satisfy one of 3 points in order to be bound by CCPA legislation. If the business has $25 million of revenue and California-based customers, then they're bound by CCPA legislation. If the business derives 50% or more of its revenue from the sale of personal user data, then again it's bound by CCPA legislation. And the last one, if the business collects the data on 50,000 or more California residents, then the business is bound by CCPA legislation. In essence, by matching one of those 3 criterias and doing business with California customers, organisations are required to comply with CCPA. The last of the 3 points mentioned, however, is actually really easy to hit as a threshold. With respect to the collection of the data of the 50,000 people, simply providing a website and getting 50,000 unique visitors will probably satisfy this test. When a visitor comes to the website, a web server logs the visit, storing information such as the visitor's IP address, which can then be used to ascertain a wealth of information, including geographical location, ISP, even potential employer if the visit was coming from a business. If the website delivers cookies, which some website software do this automatically, these cookies can be used to track the user across the website and also to store large amounts of information about the user's browser and about the user's endpoint. And by signing up for newsletters or asking to stay informed, users normally provide details such as their email address and name, all of which are considered personal information in the case of CCPA. With this in mind, 50,000 is actually a low number, working out to about 4,000 visits per month. When you consider that California has a total population of around 40 million, this is actually less than 0.01% of the population required in order to hit that limit. Another challenge that we have is what determines what personal information is. The fact is that this is also broadly defined and covers a lot. The text says that personal information is in essence any information that can be used to identify a consumer or their household, and includes things like their name, address and email address, but also online IP address and screen names and other potential identifiers. And even anonymized information is included if an organization is not able to clearly demonstrate that there are safeguards in place to prevent them from being de-anonymized or prevent the data from being able to be connected to establish personal information. With all of this in mind, let's examine a website and the data it might collect. In this example, we're using a random website, Fur Baby Couture, a website that sells clothing for pets. Whenever a visitor goes to the website, the web server logs information about the visit in its server logs. It stores the IP address of the visitor along with browser type. When examining a web server log, this information can easily be used to determine the location of the user, usually within the bounds of a city. If the visitor is coming from a business, the IP address can normally be used to determine the exact business, and thus we might be able to determine the user's employer. You can also sometimes determine whether the user is on a cell phone from their IP address and which cell phone provider they're using. Then there are things that the website uses to help them discover things like performance or user analytics. Google Analytics and other telemetry trackers collect and store large amounts of information, much of which contains information that would constitute personal identifiable information in the case of CCPA. There is a shopping cart on this website, which will no doubt collect credit card numbers, along with customer names and addresses for shipping. If this information is stored, which most stores do for convenience, then this would certainly be personal information in the terms of CCPA. And usually, to even check out, organizations ask customers to create an account, providing an email address, all of which just increases the amount of personal data being obtained and the likelihood that the organization is hitting points of CCPA legislation. And finally, tools such as the virtual assistant present on this site usually collect information so they can provide visitors with a unique personalized experience, even bringing details about past shopping experiences and suggesting items that they might want to take a look at. So because of all of this information that the website collects, either intentionally or inadvertently, the business is likely to hit the requirement to comply with CCPA if it has just 50,000 unique visitors from California. This highlights just how easy it is and how low the threshold is in order for a business to need to implement measures to ensure that they are compliant. While we certainly expect the big organizations, the Walmarts, the Targets, the Macy's, we expect their need to comply. When looking at a simple website, we can quickly understand that there's actually many organizations, both big and small, in the CCPA compliance camp. So if a business falls into having to ensure that they are CCPA compliant, what are their obligations? One obligation is for the business to provide their customers with a right to opt out of the sale of their information. Not all businesses sell their customer information, but many do, as it provides an additional revenue stream. Even if the customer is not selling their information directly, third parties that they utilize, again, for analytics or tracking, may in turn further sell on their information. Regardless of whether they do or do not sell information though, organizations need to provide users with the ability to decide not to allow this using a simple, clear website form. Given the text as it is defined, email-based requests are likely not appropriate. Another thing to bear in mind with this and all of CCPA requirements, is that organizations cannot discriminate based on a user's choice. They're not allowed to deny service to users because those users choose not to allow their information to be sold. There are lots of websites that have messaging such as usage of this website implies your consent. These are not likely acceptable and down the line will probably be found to be in violation of CCPA law. Another obligation is that the organization must inform customers about the information being collected and its purpose either before or at the point of first collection. This means that when a user first visits a website, they must be provided with a notice and even potentially their ability to control their usage data at that very point. If the user is asked to go to additional pages or they themselves have to find the CCA policy, maybe down in the footer, and information like that, it is likely that this is not considered first collection and will potentially be a CCPA violation. Many organizations do this through pop-up forms, but some choose to have a small link that within their footer. While not yet proven in court, the latter would probably not be acceptable. Organizations are also obligated to provide users with simple management of their data. Under CCPA, users have a number of rights over their data, including the right to access any of their personal information which has been collected, the right to know what the information is doing with their data, and the right to request that their data be erased. Information about their data and how it's used, along with their ability to request things like deletion, must be clearly presented to the user in a simple to use interface. Asking the user to email their requests would likely be considered overburdening and could violate CCPA. And of course, the big challenge with CCPA is that it's still new and there's much of it open to debate and interpretation. There haven't really been any cases yet to define case law or set precedent on how the law will be applied, and because of this, it's still largely unpredictable on how courts will bring judgment. With this said, however, your organization or you probably don't want to be the ones in court battling this, as the first cases will likely be long and certainly expensive. But while CCPA is still very much in its infancy stages, the penalties for non-compliance can still be severe. Along with injunctions against businesses, civil penalties are defined at $2,500 per each negligent violation and $7,500 per each intentional violation. More so, these penalties have no limit. Consider this. If a component that is used on your website to provide a virtual assistant accidentally leaks the information of just 10,000 customers, the potential penalty stands at $25 million. If your website was found to be not complying with user choice in terms of their data and your website saw just 1,000 customers, the penalty for such CCPA violation would stand at $7.5 million potentially. With such high potential civil penalties, you can probably rest assured that law practices will have dedicated business units just to push litigation against organizations for CCPA violations. So how can ENSICHTEN help your business get and stay compliant with CCPA? One question to ask is whether your current CCPA messaging and opt-out mechanism on your website is complying with CCPA as the law is written. As we have already determined, CCPA is largely open for interpretation, and we will soon see lawyers trying to present the text with their stance. ENSICHTEN's technology has been developed to allow organisations to implement CCPA compliance exactly how the text is defined. If, for example, the text calls for a clear consent form, then this is what is delivered on the websites that use ENSICHTEN's CCPA-based technology. ENSICHTEN's privacy and compliance technology provides comprehensive capabilities around not only CCPA, but GDPR too. ENSICHTEN provides a simple, easy-to-use interface, allowing users to understand what information is being obtained and why, what categories the information falls into, such as social media, analytics, etc. And also when such information is being sold, which parties are involved. Along with providing information, ENSICHTEN also provides interactive capabilities allowing users to control what happens with their information, such as the ability to opt out of its sale. Finally, ENSICHTEN provides full event-level reporting, allowing organisations to not only record and understand the choices that their users make, but also to be able to provide support in the event of being asked to prove compliance. But compliance is only part of the challenge with CCPA, and on its own is relatively weak without the ability to enforce the choices that the visitors make. Most compliance solutions simply take the choice of the user and pass that choice on to providers such as analytic trackers, social networking, and the various other tools and component technologies used inside the website, trusting that these providers will honour those requests. The challenge with this is that organisations have no way to enforce the choice that the users make, and is open to risk if their providers don't respect those decisions. If a user makes a choice not to allow their data to be sold, and subsequently an analytic tracker used on the website sells that user data, the organisation themselves is liable for this violation under CCPA. ENSICHTEN's technology prevents data even going to third parties if the choice is made by the user, and therefore ensures that data is not accidentally collected or misused by downstream technology providers. By having not only visibility but also control down in the website using client-side security, organizations are able to apply website restrictions based on user requests. For example, if a user opts out of the sale of their information, the website owners can restrict which data is permitted to go to any social networking plugins, who in turn would be likely to sell that type of information. ENSICHTEN is the leader in website security and compliance, bringing a portfolio of technology designed to protect your website from new and emerging online threats, and offering one of the most comprehensive compliance and privacy solutions available. ENSICHTEN's unique approach to not only providing compliance notices and user choice options, but also ensuring that those choices are honoured by first and third parties, and beyond is why ENSICHTEN is used by many of the most valuable brands. With hundreds of enterprise customers, ENSICHTEN's technology is designed to deliver a secure experience, but one that is performant to provide users with a great experience. So with that, I would like to thank you today for your time and invite you to learn more about ENSICHTEN and the technology that our organisation provides. You can hit ensighten.com/request-a-demo to learn more and also receive a live demo and explanation about how our technology works. Be sure to continue to check out our webinars and keep in touch with our updates and things that we have coming down the line.